It's a great pleasure and honor to be here in Liverpool to discuss this highly timely and, as we've already taken note, a very controversial subject. I would start off by saying that my perspective is not that of the Obama administration. It's not in any kind of deep sense and a U.S. perspective. I'm a Canadian who teaches in New York and in many ways regard myself as a kind of transatlantic person. My political alliances in the U.S., such as they exist, are really with the Bernie Sanders movement, and so that's a further indication that the perspective you're going to hear is not going to be the one that you would hear from the current administration, or especially not from the United States Trade Representative's office, which is the lead negotiating agency for the TTIP. So a number of years ago, 3 or 4 years ago, it became evident to most of the quote-unquote experts who work in my field, which is international trade law and investment law, that the negotiations of the so-called Doha development round in the World Trade Organization were not going anywhere fast and were burdened by fundamental differences of viewpoint and expectations, for example, between developing countries who wanted the existing WTO bargain readjusted in a way that was more favorable and accommodating of their perceived interests, versus many developed countries who saw the negotiations as actually forging ahead with what one might call broadly a neoliberal agenda. But then the experts got all excited about these new regional negotiations, TTIP, CETA, and TPP, and I said to them, it seems to me almost certain that these negotiations are going to fail, because in the 21st century, to conduct negotiations in secret and selectively allowing some interests into the negotiating room in effect and excluding other social interests is just not legitimate. And the level of awareness in parliaments and among the public about these kinds of issues today is much, much higher, and you're just going to eventually pay the price for negotiating the agreements that way, which is that they will fail when they have to be put to parliaments. So to go back to a little historical context, when the first time that this kind of neoliberal agenda with respect to using trade agreements to put pressure on domestic regulation and kind of try and push to a deregulatory outcome was with the creation of the World Trade Organization, the Uruguay round agreements. And if you look at such TTIP texts as have been leaked on issues like food safety and technical regulations, in many respects, these are mimic, and the TPP text as well, very much mimic what was negotiated in the WTO in the 1980s, leading up to the creation of the WTO with the Uruguay round in 1995. Now, when we go, and the difference with the prior regime, one that I'm very attached to, which was the GATT regime, is that the GATT regime resulted in lowering tariffs at a time at which the social state was actually expanding, and in Europe and also the United States. And there was a kind of mutually reinforcing dimension to the building of the social state on the one hand, and the boost to economic dynamism that came from removing many traditional forms of trade protection that were driven by mercantilist interests, especially tariffs, but also in some cases quotas and quantitative restrictions. But the GATT drew a very important line with respect to domestic regulation, which was to say that the GATT has no deregulatory or anti-regulation bias at all. It basically says that you can have any regulations you want as long as you can't discriminate against imported products or between different countries within the GATT. Secondly, as a safeguard that the discrimination norm will not be interpreted properly, the GATT has an extremely important exceptions provision for public morality, for human and animal life and health, and for the conservation of exhaustible natural resources, among other public policy goals. And so, this is the GATT regime. With the creation of the WTO in 1995, it embodies a somewhat different approach, which is much more reflective of skepticism about regulation, the idea that there's probably too much of it, that differences in regulation between different countries are irrational and not properly justified by science and so on. And so this kind of technocratic neoliberal rationality in the WTO Uruguay round agreements, particularly the technical barriers to trade and SPS, or Food and Agriculture Safety Agreement, tends to prevail over the pure non-discrimination approach. So there's an emphasis on using international standards, as if distinctive domestic regulations are per se not justified or bear a high burden of justification. In the case of SPS, food safety, there's a demand that the measures be justified on the basis of science. So we're going beyond the non-discrimination norm to, in some sense, reverse the burden of proof. So in a way, a WTO member, a state, can be called upon to justify its regulations and any trade restrictive effects of them. So, but back then in 1995, when some legislatures or parliaments were examining these arrangements, there was very, very little general public awareness, and certainly little awareness by legislators. And I'll just give you a couple of anecdotes that apparently through the German parliament, these hundreds of pages of treaty text were passed in about 40 minutes of debate, and with no translation available at all of these 100 pages in German. In the case of the U.S. Congress, the process was somewhat more rigorous. But did the legislators know what was in the agreement? Well, Public Citizen, a very well-known U.S. NGO, had a contest. They offered to any U.S. legislator, I think $5,000 or $6,000 if they would actually take a test about the contents of the WTO Uruguay round agreements. One of them finally, a Republican who had been very much in favor of this supposed free trade initiative, took the test, but he studied up on the agreements first, and he passed with flying colors and won the money. But then he said afterwards that if he had had any idea that this was the content, he never would have let this set of agreements see the light of day. And he said, this isn't about free trade, this is about limiting our sovereignty. Now, if we fast forward to today, I think we're in a very different environment where, thanks to the work of many NGOs and progressive political organizations and so forth, there's much more awareness, and it's very clear that the process of scrutiny that that Mr. Demasi has talked about within Europe has had a real impact on the negotiations. And so here I wanted to make at least a partial defense of how the European Commission, at least, has responded to this enhanced scrutiny. First of all, it's still been very imperfect in responding with transparency. But it has responded, I think, in the way in which the agreements have been negotiated. In the case of in investor-state dispute settlement, which Mr. Demasi alluded to, the proposal of the Commission for a new court system addresses, in my own personal view, in many ways the concerns about the lack of accountability, problems of bias, and conflict of interest that have developed in the use of arbitrators, and also the inconsistency and the lack of jurisprudential rigor in cases involving many important public policy questions, such as the response to Argentina's financial crisis. Now, again, opinions may differ, but I think it's really important that the Commission did respond in a constructive way. Commissioner Malmström said outright that based on consultations with the public, that there was a quote-unquote fundamental lack of trust in this system, where the existing system where corporations could sue states under investor protections, and that the Commission was going to propose something very different. Now, the United States is not happy with what has been proposed, moving to a true judicial model, so it may never see the light of day. But looking at the leaked texts, the Greenpeace leaked texts, I think I'm kind of reassured that the Commission in many ways has heard the message on issues like cosmetics and other controversial issues where civil society has really pushed and progressive political parties have pushed for careful scrutiny. The Commission really is holding out against United States demands. And the kind of texts that are emerging, and again, this is not any excuse for not continuing the careful scrutiny. The kinds of texts that are emerging, I think, suggest that Commissioner Malmström is basically being honest in saying that the EU's negotiating position is that it will not accept those demands of the United States that really result, that would require the undermining of existing legal and regulatory standards in the EU. And this, of course, is causing a very slow and frustrating negotiation. But to my mind, that's a good sign, which is that the Commission is now, at least, I think, really listening to civil society. It realizes that all of this will have to be carefully examined by parliaments, and it's behaving accordingly. But because it's behaving accordingly, it seems to me that one shouldn't expect any dramatic breakthroughs soon. Does this mean that I like TTIP? Not necessarily. I think that it really duplicates many of the features of the WTO on regulation, of which I've been critical, but which the WTO's appellate court has kind of scaled back and taken through a much more balanced and conservative, in the sense of less sovereignty restricting reading of many of these legal provisions. If one shifts now to a new dispute settlement system, will that new dispute settlement system encompass the kind of deference to national policies that has been reflected in the way that the appellate court at the WTO has read many of these provisions? I think that's an important question. Another two related questions. One is that the appellate court of the WTO has also held that certain provisions in the WTO treaties constitute a right to regulate. And in recent case law, the WTO appellate court has also said that you cannot take away rights and obligations in WTO agreements except through the amendment procedures of the WTO itself. So if TTIP is going to be somehow restrictive of the right to regulate as it's incorporated in the WTO, that may not be upheld, because that may be viewed as, in a way, an illegal amendment of rights that have been guaranteed to regulate in the WTO agreements. Another complex relationship between TTIP and the WTO is the non-discrimination obligation of the WTO, most favored nation. There is an exception for preferential tariffs. So there's little issue that you can avoid the most favored nation obligation if you reduce tariffs between the United States and the EU. You don't need to reduce them to the same level among every WTO member. But there's no such carve out with respect to regulatory or non-tariff measures. So that if the idea is that there will be some special regulatory arrangements between the EU and the United States, in TTIP, those will be very easily subject to challenge in the WTO as a violation of the most favored nation provision. And in theory, any other WTO country could come in and say that by virtue of most favored nation, we are entitled to exactly the same rights and privileges with respect to regulation as say, the United States is vis-a-vis the EU in TTIP. And it's quite remarkable to me that the negotiators don't seem to have gotten their head around this problem, which makes, in a way, many of these supposed concessions, although I don't agree necessarily with those concessions, it makes them largely worthless in terms of a special relationship between the EU and the United States. If TTIP ever goes through, I would expect many challenges on the regulatory front by third countries in the WTO.
That is spectacular.